Hello and welcome back to Hindsight. I go by the name of Heinz, also known as Ketchup Man. Thank you so much for tuning in for another video. On this video, we are talking about false allegations and how a lawyer was fired because of an accusation made to him, despite him proving it was false. This story comes from Legal Futures. I'm going to read the article here. The article says a leading city law firm unfairly dismissed a senior associate for sexual misconduct after a defective investigation and disciplinary processes, and employment tribunal as rule. So basically, he took this to an employment tribunal because he felt that he was unfairly sacked and there was no real investigation into it, and from there he won that case. But however, he was still dismissed and he wasn't allowed back into the company. He found the evidence supported one stance of misconduct, that he put his arm around a colleague, and that dismissal was not a reasonable response to this. That's what the tribunal found. You're telling me that he lost his job because he put an arm around an employee. Let's see how far this goes. Phil Fisher also failed to give proper weight to clear evidence that a female colleague lied in her claim of what happened in a separate incident. Djamshid Rustambekov, I know I probably pronounced that wrong. I do apologize. But yeah, was a senior associate in the dispute resolution team at Phil Fisher. He was dismissed in November 2023 as a result of two incidents. First, it was alleged that in January 2023, he sexually harassed colleague number one by repeatedly inviting her to cancel her Uber and return with him to the office following a party organized by another employee. Second, it was alleged that in July 2023, he had acted inappropriately towards colleague number two at a work party at the Savage Garden rooftop bar at a Hilton hotel near Tower Bridge by following her to the toilets, placing his arm around her waist and waiting for her outside the toilet. There was a third, more serious allegation of involving colleague number one at the July party, which was crucial to the case. She claimed that Mr. Rustambekov had been waiting for her outside the toilet, and when she left them, he grabbed and pulled her into the neighboring disabled toilet. She said he locked the door, forcibly kissed her, and tried to pull his hand under her skirt before he let her leave. Colleague number one made a complaint about this, during which she referred to the January incident and also highlighted the solicitor's conduct towards colleague number two. An HR manager investigated and recommended disciplinary action. Mr. Rustambekov was suspended pending the outcome. At a disciplinary hearing held by partner Ramatu Banga, Mr. Rustambekov denied the allegations of misconduct. Its evidence was that following a conversation in which colleague number one had confided in him about her feelings for another colleague, he invited her into the accessible toilet to continue talking in there. He denied grabbing her and pulling her. In relation to colleague number two's evidence, he noted that she had stated that he did not cross the line. He added that he did not recall touching her waist, but that it would be inappropriate if he had. The tribunal was critical of the failure to give the solicitors transcripts of the interviews conducted as part of the investigation, and also found that some evidence from them was transposed inaccurately into the report. So this wasn't just shoddy investigation. It was also it seems very one-sided, and they seem to be violating. They seem to be not forthcoming. Is what I'm trying to say. Further, a statement in the report that there have been repeated references of Mr. Rustambekov acting inappropriately towards colleague number two did not detail who said that. Judge Anthony said, therefore, whilst the claimant did know of the charges against him, I find he could not have known of the nature of the evidence relied upon by the respondent. Yeah, of course, because it was inaccurately transcribed. Neither could the claimant have been aware of the inaccuracies in the investigation report. He was basically handicapped and he had no way of proving his case fairly. The Hilton subsequently provided a written description of the CCTV footage from the accessible toilet incident. This said, there was no evidence of force when the pair entered the cubicle. It said, according to CCTV, it seems consensual from both sides. Female A initiates a hug. Male A honors this. They are hugging for quite a while. Then started kissing, and male A gently directs towards the disabled toilet while hugging. Female A does not resist. No force was used at all. That's what the CCTV footage showed. And this was the crux of her claim that this was a serious assault that was committed, but CCTV contradicts that completely, and he was still fired despite this CCTV evidence. Though Ms. Banga considered this was inconsistent with the accounts given both parties, she only questioned Mr. Rustambekov, about it. The judge said it was entirely odd that Ms. Banga did not think it was important to question colleague number one about the discrepancies. This was a missed opportunity to test colleague number one's evidence and motive in making these allegations. So they just basically, when this guy was being dismissed, they just basically took the allegations face value, and evidence be damned, they just put that to one side and just they did not question the complainant. They just, this is wild, man. This is wild. The Hilton said it would only release the actual footage if all individuals provided consent, and colleague number one refused after taking legal advice. She refused. You knew what was on that CCTV. That's why you refused. What? Before the tribunal, Ms. Banga accepted that colleague number one's evidence about what happened immediately before entering the accessible toilet was false, but concluded that this was not deliberate. Judge Anthony said, I find there is no other way to put this. Colleague number one's version of events immediately before the accessible toilet incident is wholly unsupported by the CCTV footage described and wholly incredible. However, the issue is whether she deliberately gave false evidence. Having given careful consideration to all the documentary and oral evidence, I can find no basis to underpin Ms. Banga's reasoning that colleague number one did not deliberately give false evidence. Well, based on the fact that she wasn't questioned on it, and based on the fact that she refused to give consent, how can you come to such a finding? It's impossible. You can't. So, what was the motive for her actually giving this evidence? We don't know. I personally think it's personal interest, but to save face, but there we go. Colleague number one had continued to present an account which contradicted the CCTV footage and the description, and even though she said she no longer had a clear recollection of what happened, she nonetheless continued to allow these allegations to remain alive. Withheld consent for the release of the CCTV footage, despite being fully aware it would have shown Ms. Banga what had happened. This severely damages her credibility as a witness of fact, the judge held. Ms. Banga also spoke to other colleagues of Mr. Rustambekov at his request, who said they had no concerns about his behavior. The evidence indicated a flirty atmosphere among staff who often play the same game, snog, marry, and avoid, about their colleagues. So all of this stemmed from the game that they were playing of snog, marry, and avoid, like that they would normally play these games. So that if that was a working environment, why did this come to this? And again, like I said, I personally think that she made all of this up to save face, because it probably was embarrassing that what she did. That she probably felt embarrassed that she could not face a colleague ever again, because she probably said avoid when they were playing these games, and when it got down to it, the person that she said avoid, she was actually snogging. So who knows at this point? Well, she probably was doing more than snogging, but who knows? Mr. Rustambekov issued a grievance, but in a letter with the outcome of both the disciplinary and grievance procedures, Ms. Banga said she had decided he should be dismissed. I don't feel bad. I don't feel bad, because end of the day she could have done a much better job at investigating this. She found the WhatsApp messages provided clear contemporaneous evidence to support the general allegations, and that his conduct had an underlying sexual motive, and the evidence supported the allegations of his unwanted attention towards colleague number 2. She said she had been unable to reach a conclusion on the incident in the accessible toilet, but explained that the claimant's evidence on it remained material to her decision to dismiss. Mr. Rustambekov unsuccessfully appealed internally before bringing the tribunal claim. He said the disciplinary outcome letter was the first time he had been told about the WhatsApp messages, and refuted that they showed what Ms. Banga had found. Judge Anthony held that an employee acting reasonably in a disciplinary process would have put the additional evidence obtained to the employee for comment before a final decision. I find this was particularly important when contextualized to the facts of the case, namely Ms. Banga's own concession in her oral evidence that colleague number 1 had given false evidence regarding the accessible toilet incident. I find also acknowledged by Ms. Banga in a disciplinary outcome letter, the WhatsApp messages do not state what happened on the night of January 2023 incident, which was, I think this was the arm around the girl incident, not the July one, which was the party and disabled toilet incident. I find there is nothing within the WhatsApp messages to indicate that the claimant invited colleague number 1 to go back to the office, and that there was an underlying sexual motive to that invitation. Ms. Banga also failed to put Mr. Rustambekov a finding that his conduct was due to colleague number 1's gender. The judge went on to rule the general evidence is wholly insufficient to counteract the negative pull of colleague number 1's lies. A reference to Supreme Court guidance on how a fact-finding tribunal should deal with the impact of lies on the evidence. She said, "This is because the general evidence indicates that the claimant's behavior was not considered inappropriate by many colleagues. I conclude that the negative pull of colleague number 1's lies is such that her allegation that the claimant harassed her in January 2023 is wholly undermined." Yeah, if you got the CCTV one wrong, what makes you like it seems that the WhatsApp messages that was shown was also wrong as well. So that's 2 incidents that she lied about, basically. That's insane. Judge Anthony held that in relation to the colleague number 1, Phil Fisher did not follow reasonably fair procedure, and therefore did not have reasonable grounds for his belief in Mr. Rustambekov's misconduct. The appeal process did not cure the defects of the procedure, she added. She highlighted in particular that the failure to give adequate weight to the discrepancies in colleague number 1's evidence with the CCTV footage, as well as evidence of flirting between colleague number 1 and the claimants. They were flirting through text messages as well. The decision to dismiss him on the basis of 2 serious incidents in 6 months was also unreasonable, as it is clear the respondent did not speak to the claimant immediately or in the period post the January 2023 allegation to inform the claimant that his behavior was unacceptable. She did not even make it clear to him that what he did was wrong. In reaching this decision, I have taken into account the size and administrative resources of the respondent, an international law firm with an adequately resourced HR department. Colleague number 2 made no formal complaint, and during the initial investigations indicated that she did not feel Mr. Rustambekov had overstepped the mark or made her feel uncomfortable. So the claimant, so colleague number 2, who was roped into this, is saying that no, he did not even make me feel uncomfortable. So why is he here? Why did colleague number 1 made the claim in the first place. Why? Why? Well, these are the questions. There was, however, sufficient evidence to suggest he did have his arm around colleague number 2, the judge said. But on its own, as a first offense, this would not have been enough to justify dismissal. Judge Anthony upheld the claim for unfair dismissal. A remedy hearing will follow. In a statement, Phil Fisher said, "We are disappointed by the employee tribunal's ruling. While we do not agree with the findings, we will take time to reflect on the judgment and consider our next steps." Of course, you please reflect on this, because if your employees know that they can get sacked just for something that wasn't true, they will be trying to find other firms to work for. Because I mean, let me know in the comments, would you work for a firm that has seen the evidence and they decide not to even to disregard it and still fire you? Would you actually work for a firm if you saw that happen to someone else? I wouldn't. I would try and leave, or I'll be on edge. Let's take, for example, the male workers in the firm, right? They saw this happen to the guy. The workplace is gonna be untenable, for one, because of essentially what because they're not gonna try and relate to their female staff anymore. They're not gonna play these games anymore. They're not gonna have fun with each other. Not that borderline way of fun, which is what was happening here. Like, he would take her to a toilet, etc. Not that kind of fun, but just occasional banter with one another. But just that occasional banter with one another. What this whole campaign strikes to me as is gonna create a hostile work environment. It is basically what I'm trying to say. It's gonna create a hostile work environment. People are always gonna be on edge. The different genders are always gonna be on edge, trying to work with one another over something as silly as this, as silly as I must try and save face. Because let's be honest, that's why she did this. I don't know what came off the game. I could only speculate, but it is really bad form to find that there's CCTV against you. The company knows it. You know it. You refuse to give consent to the whole CCTV, and yet, so they better go back and look at their internal affairs and how they handle these procedures. Still, in the light of the ruling, we'll be reviewing our internal disciplinary procedures to ensure that our response to instances of inappropriate behavior is thorough and robust. Yeah, I'm glad they sent out that message, because they needed to send out that message for the reasons I said before earlier. They cannot have a hostile work environment. They cannot have people being on edge, which is naturally going to happen now because of what happened to Mr. Rustambekov. That's all I have time for today. That's all I wanted to say. I am working on a longer video to detail false allegation. There is an individual that I interviewed on his false allegation and how that happened, which I aim to release on the channel very soon. So stay tuned for that. Thank you so much for tuning in for Thank you so much for tuning in for another video. Take good care of yourself. If you'd like what you've seen, make sure you hit the like button as well as the subscribe button. It would be lovely to have you guys here going through these stories. And also, if you'd like to see more court trials and court drama, make sure you check out my second channel, The Unintentional Juror, where we go through civil and criminal cases on there. So without further, I'm going to end it here. Thank you so much for everyone for tuning in. Take good care of yourself and have a great day. Bye bye.